I hope you.
I don't remember that being.
I hope you all feel good about yourself whenever you talk about a dog being abused and completely destroyed within a less than a year. And then you do. Where is Hacker? Does anybody know where Hacker is? Does anybody in this? I know where Hacker is. Do you know where Hacker is, sir? We're done with that. So what did I do? I went into action. Action! So I show up in court with a disqualification motion to disqualify Judge Harper. And here's why. Ms. Harper is in conflict in this case due to the fact that Randolph County Sheriff Robert Elbon, County Commissioners Chris Seiler, Dave Kelsing, elected and government officials, emphasis added, are the complainants. Due to the close proximity of these elected officials to each other, a reasonable person can deduce that the defendant cannot get a fair and impartial hearing or trial from Ms. Harper. Ms. Harper's court is being used as a continuing, page 2, harassment of the defendant by Robert Elbon and Lieutenant Talkington. The sheriff-initiated contacts have been documented through video evidence over a period of a year and a half. Prior to the defendant saying a word, Elbon contacted Lieutenant Talkington to the meeting and the intimidating, harassing behavior. Deputy Davis has lied and or omitted facts to this court on a sworn affidavit. The defendant, during his 5-minute public speech, Chris Seiler, showed his bias when being told by Talkington that he would get a warrant for an arrest. Seiler said, okay. Chris Seiler showed more bias when he called the defendant a fucking idiot in front of the entire room. Elbon is using Ms. Harper's court to continue to lie and omit facts that will enable him to continue to harass and stalk the defendant. Ms. Harper issued warrants to search property, Google account, and home. Ms. Harper has confirmational bias for Sheriff and Deputy Davis's affidavit and ignored 61-6-19A, provided that any assembly in a peaceful, lawful, and orderly manner for a redress of grievances is not a violation of this section. What you have to understand, a motion to have a judge be disqualified is it sets precedence in the hearing. It goes first. Because the judge cannot rule on that herself. It has to go to a higher judge above her, right? So I'm armed with that motion for the judge to be gone. But before I could even get to it, even before the judge entered the room, Lecta Polling, we all know great Lecta Polling, don't we? Lecta jumps in with her discovery. She throws a whole bunch of discovery on me about that thick. She starts to explain that, it's only going to be a $25 fine. And I'm just letting her go. Of course, I wish I could have recorded it, but I didn't because it was in a courtroom. So I'm going to explain it to you. The judge isn't even in the room, and she's starting to do this negotiation thing that fucking bar associations, esquires love to do. Well, let me tell you something. Honey, I'm not a fucking esquire. So she hands me her discovery, and at the bottom, there's a little CD. And I said, hey, what is this? She said, discovery. I said, okay. I said, body cam in there? Yeah, body cam's in there on the bottom of the discs. And she starts to talk about $25 fine and pay court costs, and this could all be over. All you have to do is plead guilty, and you pay $25 and you're gone. And then just as that, she said that, the judge comes in. Tracy Harper, former school administrator, Tracy Harper. That's what Tracy Harper did before she was a judge, a magistrate. She was a school administrator. Yes, she knows the ins and outs of the law because she dealt with the kiddies in school. Okay, so Tracy Harper comes in. And I said, Your Honor, I have a motion here for you to be disqualified. She goes, well, I guess this meeting is over. And I said, yes, ma'am, it is. And she said, yes, ma'am, it is. She said, I can't hear anything in this case until that motion to disqualify is heard from a higher judge. So now Lecta has already given me her discovery. It's so funny. And here's what she gave me. This is the state's response to the defendant's motion for discovery. The only problem with that is, Lecta, I never filed a motion for discovery. So how can you respond to something that I never filed? This is the first hearing. I haven't filed any motions yet except for this one. Pursuant to 62, Article 1B of the Code of West Virginia, she has to give me a statement of defendant. They're attached, and I got them. You'll see them. Result of examinations and tests attached. Documents, reports, search warrants, property receipts, blah, fucking blah. Well, you got it, right? And this. Witnesses, they have to give me the witness list. They have to give me their witness list, and so do you as a defense. That's if you ask for discovery. Witnesses intended. We got Deputy Sheriff Davis, Lieutenant B.A. Talkington, Sheriff Robert Elbon, fact witnesses. Check it out. Commissioner Chris Seiler, Security Officer Kenny Watson, Security Officer Kaylin Ketterman, Commissioner Dave Kessling, High School, the North Central Community Corrections Aaron Golden. Will supplement additional witnesses. This is a certificate of service that she served me on that date, March 2nd, the first date of trial, the first preliminary hearing. She hand delivered it that day to make sure that I got it. And she asks me, request for discovery. You are here notified that the undersigned is requesting reciprocal discovery pursuant under Rule 29 of the Rules of Criminal Procedure. All right, thank you, Lecta. But Lecta, this is the first hearing. The judge came back and said, no, Tracy Harper is perfectly okay to try your case. The judge further up said, no, she's more than good. She's good to go. She could try your case. So he did not disqualify her. I'm going to pop this on the next hearing, and the next hearing is a motions hearing. So my response to Lecta's motion is this. The state, West Virginia, Matthew Ballin, the defendant's response to the state's motion for discovery. Not pursuant to Chapter 62, Article 1B of the Code of West Virginia, the state provided the defendant documents and videos that was not requested by the defendant in any motion to this court. I do appreciate the speed in which the state voluntarily provided this material. However, I have never filed a motion, emphasis added, with this court to compel the state to disclose any information pertaining to their prosecution of this case. Pursuant to 29D, timing of discovery from the state. If discovery is requested by the defendant, the relevant discovery material shall be provided at least 21 days in advance of the date of trial, provided that the request had been made 14 days in advance. Pursuant to 29E of the Rules of Criminal Procedure for Magistrate Court, timing of discovery from the defendant. If reciprocal discovery is requested by the state, the relevant discovery materials shall be provided, blah, 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 blah. I never asked for it, so they don't have any right to my discovery. I asked this court to deny the state's untimely motion for discovery based on the fact that a motion for discovery was never requested by the defendant. The state cannot provide this court with a timestamped copy of said motion because it does not exist. Therefore, Rule 29E should supersede the state's reciprocal discovery request. In other words, the state placed the cart before the horse. The defendant is not filing a motion for discovery from the state at this time. Respectfully submitted, Matthew Ballin. Pro se. Was that a good one? Huh? Randy?
I agree with the logic of it.
But the judge said no.
It made too much sense. Just made way too much sense for that judge.
Of course, if the judge isn't going to be disqualified, what am I going to do? Well, fuck it. I'm going to ask for a change of venue. All right?